Rajendra Babu, former Chief Justice of India. Honorable Justice Grant Reith-Moller, Judge of Federal Circuit and Family Court of Australia, and Dato Ma Weng Kwai, the Third Court of Appeal Judge of Malaysia. I request the dignitaries to kindly Rajendra Babu, former Chief Justice of
Don't feel I'm handicapped. Justice will be handicapped.
Sir, second chair.
Okay, sir.
Okay.
Kindly be seated.
Ladies and gentlemen, welcome to the final round of the 18th LAWASIA International MOOT Competition, International Rounds. The arbitration is now in session. The panel for the session is Dato Ma Weng Kwai, retired Court of Appeal Judge of Malaysia, the past President of the Malaysian Bar and of LAWASIA, and the Honorable Justice S. Rajendra Babu, the former Chief Justice of India, together with the Honorable Justice Grant Reith-Moller, Justice of the Federal Circuit and Family Court of Australia as Chair. The claimant is represented
Before I begin, may I check if I'm audible to the members of the tribunal? Yes, thank you. Members of the tribunal, good morning. My name is Devon Sia, and I appear before this tribunal today as counsel for the claimants, the Republic of Kotana. Together with me is my co-counsel, Ms. Yo, and as well as my learned friends, Ms. Jana and Ms. Low, representing the respondents. I'll be presenting on the two procedural issues, which are firstly, whether Olaf should be removed as the arbitrator for the lack of impartiality, and second, whether this arbitral tribunal should stay the present proceedings until the conclusion of Anwar's trial at the International Criminal Court. My co-counsel will be submitting on the two substantive issues, namely whether the CCTA is void, and in the event it is decided in the negative, whether the termination of the CCTA by Kotana is valid. We each reserve 20 minutes for submissions and 5 minutes for rebuttals if necessary. Members of the tribunal, independence and impartiality are the cornerstones of every arbitrator and judge alike. And to be in breach of that is a serious matter that should not be taken lightly. The respondents today have appointed Olaf, an AI-powered lawyer and judge, as their arbitrator. However, justifiable doubts as to Olaf's impartiality have arisen. Therefore,
Well, before we get to that, can you tell me how it is that an arbitrator can be appointed who's not a real person?
Mr. Chairperson, allow me to clarify that firstly, we are not contending Olaf's ability to sit as an AI arbitrator. And in response to your question, we're here contending that Olaf should not sit as an arbitrator in these present proceedings. It is up to the respondents to appoint an AI arbitrator in accordance to the AIAC rules, which do not expressly prohibit an AI arbitrator, nor does it expressly state that an arbitrator must be a human.
Is it your case to say that a robot, essentially it's a robot, yes, can be appointed to be an arbitrator?
It is our stance that...
Should not an arbitrator always be a human being?
No, Mr. Arbitrator. We believe that Olaf, as an AI competent arbitrator, as seen due to his qualifications in page 6, paragraph 12, shows that he possesses the requisite qualifications to be an arbitrator. And here, in accordance with the AIAC rules, the grounds to challenge an arbitrator are...
Are you referring to the AIAC 2021 rules or the 2023 rules? The 2023 rules have just been brought into force.
We'll be referring to the 2021 rules, and this was agreed to in the CCTA.
Thank you.
Now, in the 2021 rules, to challenge an arbitrator, there are two votes to this argument. First, that there are justifiable doubts to this arbitrator's impartiality or independence. And it is on this point that we are challenging Olaf. Here, essentially, an arbitrator must always remain impartial and independent.
But
And
what's the test for that at law?
My apologies, Mr. Chairperson.
What's the test at law for that in this arbitration? Because the test in different countries is worded differently.
Yes, Mr. Chairperson. In accordance with the AIAC rules, the test is whether there are justifiable doubts. And to assess these justifiable doubts, the test is an objective one. And this was laid down in Part 1, 2C of the International Bar Association Guidelines, which is to be a point of reference as stated in the AIAC Code of Conduct for Arbitrators.
And so as an objective test, is it a fair-minded, informed observer, or is it the opinion of each of the parties, or the subjective opinion of each of the parties?
It is from a reasonable third person's point of view, Mr. Chairperson.
Yes. Is that the law in India?
Yes, Mr. Chairperson.
I'm still...
You see, do you think that it is possible for a robotic program to render justice? Justice itself is a human virtue. It is a human virtue. Can a robot render such a justice? Do you think that?
It is the claimant's opinion that Olaf is able to render justice. However, in this situation, due to his impartiality in regards to the present proceedings, he is unable to render justice, and that is why we are challenging him.
Anybody who creates a program will leave his impact on the program. Do you think that would influence his approach to the matter?
Mr. Arbitrator, this is one of the reasons that we are challenging Olaf, however, not on the grounds of his specific cognitive abilities, however, due to the fact that the respondents themselves have an upper hand in the process of programming Olaf, even though it was decided that Olaf was a joint venture between both parties. Allow me to explain. As seen in page 6, paragraph 11 of the MOOT problem, the first line in paragraph 11 states that Olaf began as the Prime Minister of Rajasthan, Prime Minister Yogyakarta's visionary plans for his own country. And further, this same Prime Minister sits as one of the independent non-executive directors of Oracle Corp, the company that produced Olaf. And although we do recognize that the Prime Minister's role in the company may be limited, however, we submit that due to the fact that Olaf began as the Prime Minister's brainchild and that he continues to have an affiliation with Olaf, that this creates an appearance of bias. Further, members of the tribunal,
But I'm sorry, if Olaf's a machine working on an algorithm, what difference does Olaf's relationship with any particular person make? If Olaf has no emotions, why would there be a suggestion of apprehended bias?
Mr. Chairperson, the apprehension of bias here can be proven through conduct, as this was stated as in the justifiable doubts as to his impartiality. And therefore, what we are contending is that Olaf's conduct, as well as the nature of relationship between Olaf and Radostan, show this appearance of bias.
So are you able to particularize the conduct for us?
Yes, Mr. Chairperson. We are contending that Olaf's social media publications and comments show an appearance of bias. And this is for two reasons. Firstly, his comments show a risk of prejudgment. And second, his comments show that he has taken a pro-Radostan stance and may be biased towards Radostan and against Koltana in this dispute. And if I may invite this tribunal to page 9
contending that
of the moot problem,
social media.
in paragraph 21. In paragraph 21, the third to the fifth line states that Olaf commented that the devastating Sapura Bay bombings and cyber attacks that occurred in Koltana could have been easily avoided if the government had invested properly in counter-terrorism measures. Now, this comment of Olaf directly relates to our dispute today, as Olaf has clearly taken a stance on what is the proper policies a state should implement in countering terrorism. This then directly relates to the merits of our case today.
I was asking a question earlier, and I'm trying very hard to understand this. Is it your case to say that a machine can be appointed an arbitrator? Never mind about the qualities and the plus points, yeah? No bias, no emotions, no feelings, and so on. Put that aside for a moment. Do the provisions allow for a non-human to be appointed?
Mr. Arbitrator, the provisions do not expressly prohibit, and this is up to the discretion of this tribunal to decide whether Olaf may be able to sit as an arbitrator.
Would you think that the authorities that drafted the Arbitration and Conciliation Act way back in '96, if not mistaken, would have thought that an arbitrator can be a machine and did not provide for it? If it's going to be something other than the norm, to be a norm as a human being, wouldn't that be expressly stated in the law to say that a machine can be appointed an arbitrator?
Respectfully, Mr. Arbitrator, we do not agree, because way back in 1996, technology has yet to develop AI arbitrators that are able to sit as lawyers and judges. Therefore, although it is unfortunate the jurisprudence has not allowed for these rules in reference to an AI, we submit that despite this, Olaf may be able to sit as the arbitrator up to the discretion of the tribunal.
I don't quite understand where you're heading, though. As I understand your case, you want Olaf removed.
Yes, Mr. Chairperson.
But you don't want him removed or it removed on the basis that it can't be an arbitrator.
Yes, Mr. Chairperson, we do not believe that he needs to be removed on the basis that he is an AI. We believe that he needs to be removed because he is partial.
All right. And you're specifically abandoning that point before the tribunal.
Yes, Mr. Chairperson.
All right.
Now moving on to Olaf's conduct, which indicate an appearance of bias. Further, in page 13, paragraph 29, here, Olaf, in an article published, took the view that the reason for the current government of Koltana's near loss in the elections was due to its poor performance over the past couple of years. Therefore, it is clear that Olaf just one, but two separate instances criticized Koltana's government's ability to govern its citizens and protect its citizens. Now, if I may cite the case of Parenco against Ecuador, in this case, the concerned arbitrator had been removed because the combination of the words the arbitrators had used to describe Ecuador was deemed to paint Ecuador in a negative and unfavorable view. Similarly, in our case, Olaf has painted Koltana in this negative light.
What did the arbitrator say in the Ecuador case?
The arbitrator in that case described Ecuador as a recalcitrant country, therefore painting a negative connotation. Now, members of the tribunal, it is for these reasons that firstly, these comments indicate an appearance of bias, as Olaf has been overly critical and harsh of the Koltana government, and second, that the nature of relationship between Olaf and Radostan, in which the Prime Minister himself created Olaf as part of his visionary plans for Radostan, and further, as seen in page 6, paragraph 12, the lack of transparency on part of Radostan in terms of programming Olaf, as Koltana was granted a limited access to said software. Therefore, although the respondents may contend that the claimants had been involved in Olaf's creation process, there must be a reason as to why this limit exists, and therefore, from a reasonable third person's point of view, members of the tribunal, anyone can see that if this was a joint venture between both states, if one state does not have equal access to this program, this would indicate an appearance of bias.
So your case is that you can appoint a machine to be the arbitrator, but you can only hold that appointment if both sides have been able to fully inspect all of the programming and data within the machine and understand how it works.
No, Mr. Arbitrator, Mr. Chairperson. However, in this case specifically, the very fact that that Olaf is the brainchild of the Prime Minister, and that the Prime Minister is still involved with Olaf, and the fact that Koltana was not given equal access, that due to all of these circumstances, that we submit that this shows an appearance of bias.
Yes, thank you.
Now, this then takes me to my second grounds of submissions. This arbitral tribunal should not stay the present proceedings until the conclusion of Anuwat's trial at the International Criminal Court. And allow me to provide some context. As our current AIAC proceedings commence, a simultaneous ICC proceeding is happening at The Hague right now. There, Anuwat, who is the CEO of Unitec, is involved in these proceedings. Therefore, it is precisely for this reason that the respondents are requesting for a stay to allow Anuwat to provide his witness testimony before this tribunal. However, it is the claimant's submission that this stay should not be granted for two reasons. First, the ICC proceedings have no material outcome on our current proceedings. Second, in place of Anuwat's physical witness testimony, there are other fairer alternatives which would not lead to an unreasonable and indefinite stay of these proceedings.
So, does Anuwat's evidence have some bearing on this case?
Mr. Chairperson, the claimants submit that it has no bearing on our case because the claimants are not basing our case on Anuwat's testimony. However,
So you're not calling Anuwat to give evidence?
No, Mr. Chairperson. However, in this case, we still do acknowledge the respondent's right to be heard and Anuwat's right to provide his witness testimony if called by the respondents. And to this, we submit that instead of a physical witness statement, that Anuwat may be able to provide his witness testimony virtually without having to wait for the ICC proceedings to end.
Could it be unfair to Anuwat to require him to give evidence and be cross-examined prior to his criminal trial?
Mr. Chairperson, for this, we have three reasons. Firstly, we have our main reason here is that the ICC proceedings have no relation to our current proceedings. And therefore, regardless of Anuwat's outcome at the ICC, it will have no bearing on his testimony here in this tribunal. And this is for 3 reasons. First, the different parties. Now, the ICC proceedings relate solely to Ulavu, an entirely different state, while our current proceedings involve Kotana and Rajasthan. Second, the different issues at hand. The ICC proceedings relate to the suspected commission of cyber war crimes in Ulavu, while our current proceedings relate solely to the contractual operation of the CCTA between Kotana and Rajasthan. And accordingly, the ICC will determine whether Ulavu has committed cyber war crimes, while these proceedings will determine whether the CCTA remains operative.
Is Anuwat under detention?
Yes, Mr. Arbitrator. Now, on the third reason, on the different applicable laws, the ICC will operate on the Rome Statute, while this arbitral panel will operate on the contractual rules as well as Indian law. Therefore, clearly, there is no nexus between the 2 proceedings, and there should be no reason for this tribunal to grant this unreasonable and indefinite stay. Further, as my co-counsel will explain, we are not relying on the Ulavu files to prove Onion Ring's illegality. Therefore, we find no reason to wait for the outcome of the ICC and to suspend these proceedings.
So what do you understand to be the purpose of Anuwat's evidence when they call him as a witness?
Mr. Chairperson, we believe that the respondents intend to call Anuwat upon this tribunal today to provide his witness statement as stated in paragraph 39 of the MOOT problem, where he has stated in the International Criminal Court to shed light on matters. However, at this juncture, we are unsure if Anuwat even intends to appear before this tribunal today, as we have no witness testimony or preliminary witness statements from Anuwat.
So would you say that we ought not to determine a stay until we at least see a witness statement or an outline of the evidence they expect this witness to give?
This is at the discretion of the tribunal, Mr. Chairperson. However, in this case, we believe that the respondents have not shown that Anuwat intends to come forth and provide his testimony due to the lack of documents, and therefore we submit that the stay should not be granted for just 1 witness.
But Anuwat is a competent witness to give evidence if the need arises, right?
He is, Mr. Arbitrator. Once again, we are not depriving of the respondents' right to be heard or Anuwat's right to provide his testimony. As explained, this tribunal has the jurisdiction to allow virtual hearings. This was clearly embedded in Rule 28 of the AIAC rules, where this tribunal may direct that witnesses be examined through means of telecommunication.
If he's in detention, will the detention authorities permit him to give evidence by video to an arbitral tribunal?
Yes, Mr. Chairperson, and this is in relation to Rule 134 of the ICC Rules of Procedure and Evidence, as in the excusal from trial, which would allow Anuwat to provide his witness testimony virtually. And with this, yes, Mr. Chairperson.
Thank you.
And with this, it is therefore now for the respondents to respond as to why we should wait these proceedings for just 1 mere witness who would not have much bearing on our case today. And with that, I conclude my submission. Thank you.
Yes, Ms. Antung.
Before I begin, may I just check whether am I audible?
Yes.
Thank you. Mr. Chairperson, members of the tribunal, my name is Yo Eun-tong, and I appear before this tribunal as the co-counsel on behalf of the claimant, the Republic of Kotana. Members of the tribunal, our nation was faced with terrorism and cyber attacks. until the shedding light on the darkness, the assistance provided by Rajasthan, with onion ring as the solution. Regrettably, onion ring did not only transgress, and it transgressed the right to privacy of Kotana citizens, and it subsequently failed and had caused my client to suffer a loss of USD 300 million overnight. Members of the tribunal, as mentioned by my lead counsel earlier, I will be submitting for the next 20 minutes on the merits, Issue 3 and Issue 4, whereby for Issue 3, whether the Kotana Rajasthan Counter-Terrorism Agreement, hereinafter referred as the CCTA, is void. And as an alternative, if Issue 3 is to be determined in the negative, we shall look into Issue 4, whether the termination of CCTA is valid. With that, I shall now proceed with my submission on Issue 3, whereby the claimant avers that the CCTA is void for the reason of illegality as it infringes the privacy of Kotana citizens. Before I begin, for preliminary purposes, the claimant would like to clarify a few points. Firstly, the Indian law is the governing law as of the merits today. This is stated in the MOOT problem, page 12, paragraph 25.5.
I think we're aware of that.
Yes, thank you, Mr. Arbitrator. Hence, the Indian law will be the governing substantive law. Secondly, a contract is not legally enforceable if its object is illegal. For example, it is opposed to the public policy, which is right to privacy in our current circumstances. And this is pursuant to Section 2, subsection J, and Section 23 of the Indian Contracts Act, which provides such ground to call a contract to be void. Last but not least, members of the tribunal, we do acknowledge that the CCTA's purpose is to combat terrorism and cyber attack, but with bulk interception and mass surveillance. And in order to carry out the object, it necessitates an illegal action. This would still render the CCTA to be void, and this is propounded by the Indian Supreme Court in the case of Gerulal Parak against Mahadodas Maya. With the preliminary points clarified, I shall now move on to my first layer of argument for Issue 3. We demonstrate that the CCTA is opposed to public policy for breach of privacy. And my second layer will be, in any event, CCTA does not fall under the exception of privacy. To my first layer of argument for Issue 3, we aver that the CCTA's object is opposed to public policy. Members of the tribunal...
In the absence of an oath, you can't go on with the case.
My apologies, Mr. Arbitrator.
Supposing the International Criminal Court sentenced him to jail, will he be able to appear before the tribunal?
Mr. Arbitrator, I believe you're referring to Anwat at this juncture. However, we are not using Anwat's testimony nor Anwat's relation for our basis of claim.
Perhaps Ms. Devon could answer that question. We'll extend your time to account for that. Would you like to answer the arbitrator's question, Ms. Devon?
If I may clarify, is Mr. Arbitrator asking if Anwar were to be detained, would he be able to provide his witness testimony? And this is precisely why we propose for a virtual hearings at this process before the conclusion of his trial to ensure fair rights to the respondent.
So if he's found guilty, he'll still be able to give video evidence from wherever they imprison him?
Yes, Mr. Arbitrator, Mr. Chairperson.
Yes. Thank you. Yes, Mr. Omkong.
Thank you, Mr. Chairperson. Thank you, Mr. Arbitrator. Moving back to my submission, the Indian Supreme Court in the case of K.S. Puttaswamy against the Union of India, this is a landmark case that propounded that right to privacy is inherent in all individuals, which includes right to be left alone and free from surveillance. Members of the tribunal, if I may refer this tribunal to MOOT problem, page 9, paragraph 23, specifically the last two lines of paragraph 23. Now, we can see that onion ring to remotely and covertly extract intelligence from various devices. This would constitute mass surveillance and bulk interception. And this is ruled to be illegal by the Indian Supreme Court in the case of PUCL against Union of India. It is also important for us to dissect these terms. What does it mean to be covertly and remotely?
Sorry, can you just tell us a little more about what PUCL said?
Yes, Mr. Chairperson. In PUCL, the Indian Supreme Court stated that bulk interception is not allowed. Instead, targeted interception is allowed if it's for the national security purposes.
Yes, thank you.
Thank you, Mr. Chairperson. With that, the claimant submits that the CCTA's object is illegal because by conducting bulk interception and mass surveillance, this would infringe the right to privacy of Koltana citizens. Hence, we submit that the CCTA is unenforceable by law, hence void, as it is opposed to public policy, and this is one of the grounds provided by Section 23 of the Indian Contract Act to call an object unlawful.
But your client, oh, sorry, go on.
You're referring to the last limb, is it? Where the court regards it as immoral or opposed to public policy.
Yes, Mr. Arbitrator.
Okay.
Yes, Mr. Chairperson.
And your client entered into this contract for the very purpose of having bulk covert surveillance.
Mr. Chairperson, allow me to clarify. We enter into this contract is to combat terrorism and cyber attacks. Perhaps there is an oversight from my client and the respondent's client that bulk interception is not allowed by the Indian governing law and only targeted interception is allowed.
Is it allowed by the law of your country?
This is silent in the MOOT problem because we don't know what is the Koltana law at this time.
Assuming that there's no legal prohibition in Koltana.
My apologies?
Assuming that there is no legal prohibition on this type of surveillance in Koltana, that is, that it is legal in your country, would it then be contrary to public policy to enter into a contract for a legal activity in your country, even if that activity were illegal in India?
Mr. Chairperson, in response to that, we must emphasize that Indian law is the governing law as per this CCTA, and we are contending that the object of CCTA is against the Indian law.
So the Indian law restricts what can be done in your country?
Yes, because it is the CCTA's object.
Because of public policy, not an express prohibition?
Yes.
So if Indian law said that you have to have a license to sell beer, and people sell beer in your country without a license, it would be illegal contracts under this arbitration.
Mr. Chairperson, could you please clarify your question?
So, for example, if the Indian law said that you have to have a license to sell beer, and in your country you don't have to have a license to sell beer, and a person enters into a contract without a license, and it comes on arbitration, you say that that contract would be illegal because it's contrary to Indian public policy.
Mr. Chairperson, this is due to one reason. This CCTA, this contract was to be determined by the Indian law for its merits, then yes, that would be illegal.
Do you think that we might consider that the meaning of public policy in this context wouldn't be intended to restrict activities that are lawful in the other country?
Mr. Chairperson, even if this tribunal is not with me on right to privacy falls under public policy. However, in Article 1 of the CCTA, both parties have to comply with the international law. For example, ICCPR, as stated in Article 1, Roman 2 of the CCTA. And in ICCPR, it expressly provides right to privacy under Article 17 of the ICCPR.
Isn't all that overridden by the need to fight terrorism?
Yes.
Any fight against terrorism must be in the public interest, public policy. Doesn't that override the right to privacy? The bigger good, so to speak. What's your response?
Yes, Mr. Arbitrator. In response, we must look into the case as decided by the Indian Supreme Court in the case of PUCL against Union of India. Once again, the Indian Supreme Court has stated that although there may be a compelling public interest, for example, national security, like in these current circumstances. However, the right to privacy of innocent citizens should not be deprived. Instead, the government should only target on two types of people. Firstly, those with past criminal records or those who possess a security threat. Hence, at this juncture, a blanket scale of surveillance would deprive the right to privacy of innocent citizens.
And so if a company in India supplied all of the hardware to Kaltana to run this software, that would be an illegal contract as well.
Yes, Mr. Chairperson.
So India might have problems with exports to other countries, because if it sends anything to a country where it's legal in the foreign country but illegal in India, it's an illegal contract because of public policy. Is that your argument?
Mr. Chairperson, the answer is no, because we will still have to look into whether the interception itself falls under the exception of the right to privacy. And this is the three-part test as laid down by the Indian Supreme Court in the case of K.S. Puttaswamy.
But the more general proposition you're putting is that if something is contrary to the law of India, but it's perfectly legal in the other country, then under the agreement it's a void contract or an illegal contract. So if anybody in India is supplying something to another country that might be used for a purpose that's illegal in India, then they would have an illegal contract, even if it's legal in the other country.
Mr. Chairperson, this will be determined on what is the substantive governing law of that particular contract. And members of the tribunal, moving back to my submission.
One other question. Is it your case that the CCTA has been fraudulently used or applied by the respondent?
No,
Are you alleging fraud here?
No, Mr. Arbitrator.
All right.
Thank you, Mr. Arbitrator. Mr. Arbitrator, as mentioned earlier, the right to privacy has its exception, which is the three-part test: legality, necessity, and proportionality. Due to interest of time, I will be only addressing the two most contentious elements: legality and proportionality. First, for legality, we submit that onion rings interference is not provided by law. Gobbin against State of MP of the Indian Supreme Court case is a great example for this principle. The current law, the current Indian law that provides for interception is Section 5, Subsection 2 of Telegraph Act and Section 69 of Information Technology Act. And last but not least, Section 7, Subsection H of the Digital Personal Data Protection Act 2023. However, the Telegraph Act and Information Technology Act, it was expressly stated in that only targeted interception is allowed, but not bulk interception. Perhaps my learned friend may raise Section 7, Subsection H of Digital Personal Data Protection Act 2023. However, we submit that nevertheless, this statute is only gazetted and come into force on 11th of August 2023, which is 2 years after the formation of CCTA. Hence, it does not have retrospective value at this juncture. Last but not least, regarding proportionality, because it is not proportionate for its bulk interception, its its interception on a blanket scale would constitute a mass interception. And in essence, we contend that since onion ring has failed the three-part test, the three-conjunctive test, we submit that onion ring and CCTA does not fall under the exception of right to privacy, hence illegal. Nevertheless, members of the tribunal, if this tribunal finds issue 3 to be determined in the negative, we shall look into issue 4. We submit that the termination of CCTA is valid for the reason of fundamental breach of CCTA. According to the Indian Supreme Court, in the case of Maharashtra State Electricity against Data Switchgear in the year of 2018, a fundamental breach is a breach that it relates to the root of contract. Members of the tribunal, the main objective of CCTA today is to combat terrorism and cyber attacks. However, the respondent has failed to fulfill their main obligation by breaching the main purpose of CCTA, and this is evident in the MOOT problem, paragraph 32. That the biggest modern daylight robbery has occurred, and we had suffered a substantial loss of USD 300 million overnight.
So are you saying that the contract was that Onion Ring would guarantee the security of Koltana, or are you saying that Onion Ring wasn't fit for purpose, or are you saying that it was negligently constructed, causing loss, or some other legal theory for the basis of the breach? Perhaps if I give an example, I pay my doctor to keep me alive. Does that mean that he's liable if I die?
We should hold him.
Mr. Chairperson.
And clearly not, because there's a lot of reasons. He may have done everything possible to keep me alive, and I might still die.
Mr. Chairperson, we do acknowledge that there is a fair concern. However, we have two responses. Firstly, we have to consider the magnitude of the damage. Here, my client has suffered a colossal loss of USD 300 million overnight. And secondly...
Not quite as bad as dying.
No.
How long had the agreement been running before this termination?
Yes, Mr. Arbitrator, that is a right concern. This CCTA has merely been entered in 4 months, which is less than half a year. Although we must acknowledge that there is indeed the success by Onion Ring previously, but we also must look into the substantial amount of our investment, which is USD 50 million.
What was the unexpired period?
2024.
Yeah, how many months more to go?
There was 2 years more to go when the Bitcoin robbery occurred.
Right.
So are you saying that they're strictly liable? You don't have to show that it wasn't fit for purpose or that they were negligent. The mere fact that there was a robbery means that they haven't fulfilled the contract. I'm sorry, we said we'd give some more time for before. Timekeeper, we'll perhaps give her another 5 minutes. She's had a lot of interruptions.
Mr. Chairperson, before I answer your question, may I request an extension to answer your question?
Yes, I'll give you a further 5 minutes.
Yeah,
Yes.
right.
Five more minutes.
Thank you, Mr. Chairperson and members of the tribunal. So, Mr. Tribunal, my apologies. Mr. Chairperson, allow me to clarify our stance. We are not placing an unreasonable burden on the respondent to completely prevent all the cyber attacks or terrorist attacks. We do acknowledge that there was indeed success of Onion Ring, and there could be a mere outlier. But we must look at the damage we suffered, and also the substantial amount that we have invested into this contract. And within 4 months, which is less than half a year, they had breached the core purpose of the contract. Perhaps to terminate this contract is a better option for my client and also for respondent, because it allows us to opt for a better and more effective cybersecurity software to prevent this from happening again.
Upon termination, is it the claimant's case that there would be an immediate stop to the use of the software, the onion ring software?
Yes, Mr. Arbitrator.
Coltana is not going to continue using it
Yes.
for the unexpired period.
Yes, Mr. Arbitrator, perhaps you may have concern regarding why we would want to retain the onion ring.
Yes.
However, it is for investigation purpose as stated in the MOOT problem. And it is not for any commercial reasons or any purpose that benefits us. And this is in fact under Article 1 of CCTA, that is the general obligation by both parties to comply with Arms Trade Treaty Act. And in Arms Trade Treaty Act, Article 15 of that statute, it's expressly stated that the parties entered into the treaty must assist each other in the case of investigation. Thank you.
Thank you.
So members of the tribunal, we maintain that our stance is, considering to witness such a substantial loss, we do not want to afford another cyber attack or terrorist attack at worst to occur again if onion ring's efficacy remains in question. And we submit that 1. Olaf should be removed as the arbitrator for lack of impartiality. 2. The stay of proceedings until the conclusion of Anwar's trial at the ICC is to be denied. 3. The CCTA is void for the reason of illegality. 4. The termination of CCTA is valid as of our rights as the aggrieved party. If I may no longer assist this tribunal.
It just strikes my mind that if you are right, the claimant is right, that Olaf can remain as an arbitrator. You'll be talking to three of us, nobody's here. There's nobody to look at you and to respond. You won't see the body language of the arbitrator and so on. You think really that is good in the development of resolution of disputes?
Mr. Arbitrator, may I clarify your question?
No, if Olaf can be appointed as an arbitrator, continue as or to be an arbitrator, then none of us would be present here. You'd be talking to an empty chair. Is that good?
Mr. Arbitrator, respectfully, we are not contending Olaf's ability as an arbitrator because he is an AI. And an AI arbitrator present in this tribunal could be something that may occur in the future that we may not
I think the
know.
comment made by Learned Chief Justice just now was that justice must be human justice, not machine justice. Is that right? I'm very worried, actually, that one day machines will sit here and not us. So, you know, you're laying the foundation for a very, very important development in law. But just because it's not precluded in the Act or in the rules, does that mean to say it can be done? Sorry, I know this was an issue taken up by Devonshire, but good to see how you respond to that.
Respectfully, it may be a reasonable concern for this tribunal to consider AI should not be an arbitrator. But respectfully, we are not contending Olaf's ability as an AI. And it is for the respondent to argue on this matter. With that, I conclude my submission. Thank you.
Thank you. Thank you. Yes.
1 minute, if I can score.
Yes, good idea. Just a moment while we make some notes, please.
Yeah, sure, definitely.
Yes. Thank you, Mr. Chairman.
Thank you. Good morning, members of the tribunal. As earlier introduced, I am Shruti Harini Janardhanan, and together with my co-counsel, Ms. Alyssa Low, and off-counsel, Ms. Christiane Yap, we appear for the respondent, the majestic kingdom of Rajasthan. I will be responding to the first two procedural issues on whether Olaf can sit on this panel as an arbitrator for lack of impartiality, and the second procedural issue on whether a stay should be granted. And my co-counsel will be addressing the substantive issues of the debate on whether the Koltana-Rajasthan counterterrorism agreement is void or, in the alternative, validly terminated. Members of the tribunal, a fundamental aspect of the arbitral process is the autonomy of parties to pick an arbitrator who suits the specific needs of a dispute. For this very reason, the threshold to be met when a party seeks to remove an arbitrator is a high one. For an arbitrator to be removed for the lack of impartiality, it must be clear that he has closed his mind to all the merits of the dispute. And as for this legal burden, we will go on to show how the claimants have not discharged this burden. However, before we move on into investigation into the standard of impartiality, we would like to address preliminary concerns on whether Olaf, as an AI arbitrator, can even sit on this dispute. Now, we note that the claimants have not raised any contentions on whether Olaf can sit on the dispute, but regardless, we would like to assuage the concerns of this tribunal and make reference to the relevant laws. Preliminarily, the Indian Arbitration Conciliation Act and the AIAC rules do not make specific reference to a human person or natural person, as pointed out before, in contrast with the French, Portuguese, and Dutch legislations. However, we do note that, as mentioned by Justice Grant as well, since this act was enacted in 1996, it cannot be said that it contemplates an AI arbitrator. In fact, if we take reference to the IACA itself, there is reference made to employee, advisor, and person, which are roles that are traditionally used to inform roles of a human being. However, in this case, our argument is that Olaf can fulfill the purposes of an arbitrator for the purposes of this dispute. Justice Babu had mentioned, how can a human virtue like justice be enacted by a robot? How can a robot render human justice? In this case, our argument is that Olaf is unlike any AI robot seen before and has developed through machine learning beyond mere robotic machine-fixed AI systems like ChatGPT or Bard. Olaf is able to arbitrate on complex legal disputes, and this is as seen in the facts, as mentioned by claimants as well, in paragraph 12, page 6.
Well, how do we decide, if we follow your argument, when a machine reaches the appropriate level? For example, my toaster has artificial intelligence. It turns itself off when the toast is done. It couldn't be an arbitrator. Bard or ChatGPT-4 probably couldn't be an arbitrator. What test would we apply if we accept that you can have a non-human arbitrator?
And perhaps this also concerns to Dato's earlier concern on whether if we have a machine sitting on as an arbitrator, then we will also not be able to have the tactile experience of having a machine and of seeing body language and interacting.
Could you come back to my question?
Okay, sure. So to address your question on whether, when we know at which point of development an AI arbitrator can arbitrate on a dispute, well, in this case, we can take reference to how an AI arbitrator, at which stage of development, it forms neural networks such as to minimize effects that AI machine learning now faces, like disingenuity and creating and hallucinations. And perhaps when it crosses this level, and if there is proof that it is able to arbitrate on different disputes, either as counsel, as arbitrator, or in wear various hats. So the point I'm trying to make is that Olaf, in this case, wears various hats as arbitrator, counsel, and mediator, which is distinct from other AI softwares in practice today, which means that it is able to wear different hats and has reached a stage of development where it may be likened to a human person reasonably. And in this case, since Olaf has acted as arbitrator and counsel and mediator, and also a legal publisher of insights, arguably each one of these purposes require a different skill set. And since various governmental bodies and private entities have engaged Olaf to represent them in disputes, it can be argued that Olaf should be treated like a human person, and any biases that may be within Olaf that we cannot see is not unlike a human arbitrator whose biases we also cannot see.
Well, people have already engaged ChatGPT in legal disputes. Somebody even won a strikeout application in the US. Does that mean that it would be suitable to be an arbitrator?
Well, as for ChatGPT, I would not go so far to say that ChatGPT would be able to act as an arbitrator, but ChatGPT can be distinguished from Olaf in this case due to the experience that Olaf has in arbitrating disputes. And perhaps in line with this line of questioning, if I could address Dato's question on the physical, human, tactile part of the arbitration experience, and whether if we were sitting here and an arbitrator were a machine, then would that remove the human touch and perhaps bring us towards a future that we do not want to contemplate? Well, in this case, we argue that Olaf has been recognized, or there were plans for the claimant themselves to recognize Olaf as a super intelligent human person affixed to a machine, and machines can develop in order to emulate human-like characteristics, so perhaps it may be possible for a machine to develop to the extent that it is also
Will
able
it
to
not
sit on a
have
dispute.
bias of the creator?
Well, specifically for the purposes of this dispute, we understand that perhaps the claimant has also argued that there may be biases of the respondent since claimant engagement was reduced after the commencement of Project Olaf. However, here, if I could refer members of the tribunal to the facts at clarification 2, page 1 of the clarifications, so it's not the main moot problem. Clarification number 2. So over here, we can take a look at the training data used to train Olaf, and at the second line of the second clarification,
In para 13, they specifically allege that there has been some unusual behavior on Olaf.
yes.
How do you answer?
So preliminarily, the information that, or perhaps the output that Olaf has made, it could seem that this is unusual, but if we take reference to the clarifications, we can see that the claimant themselves were involved in the input of data to assess whether or not Olaf is biased. And as for the opinions mentioned by Olaf, the legal standard of impartiality, as mentioned by the claimant, is that of a fair-minded observer. So earlier, the point I was making with clarification 2 is the fact that it is disingenuous for the claimant to say that there is biases in the creation of Olaf when in the input of legal training, the claimant themselves were involved in the filtering of websites to ensure, and I read, that Olaf functions accurately and independently of unverified information. But as for the opinions themselves, perhaps I could go through the opinions raised by the claimants in turn and explain why they do not meet the legal standard of
So what you are saying
impartiality.
is that because Koltana had a hand in the development, therefore they are now stopped from, allowing it to be used. Is that what you're saying?
In the legal sense, while they may not be stopped, it would be perhaps contradictory for Koltana to say that the input of information in Olaf is biased and was unilaterally done by the respondents when it is clear on the record that they too had a hand. Turning to the specific fact references that the claimant mentioned, this would be found at paragraphs 21 and 29, and I will go through them in turn.
Sorry, before we go to that, you said before that there were moves to recognise Olaf as a person
Yes.
by your client, but your client decided not to.
It was the claimant's government, this is found at page 6, paragraph 12.
Have I got the government's back to front, have I?
Page
Have I got the government's back to front, have I?
6, paragraph 12. The last 4 lines, I apologize, the line in the middle of the paragraph that begins with the word participation. So the claimant's Ministry of Technology, after successful participation, so this is at page 6, paragraph 12.
Yes.
The line that begins with participation in the middle of the paragraph.
Yes, but the point is Olaf wasn't recognised as a person.
And this was a choice of the claimant government, so this is something independent of the respondent.
So how does it help your argument that somebody might have thought about it but decided not to do it? They've made a decision that Olaf's not sufficient to be recognised as a person.
We are unsure why the claimant has made this decision. And we are also unclear, and perhaps the claimant can provide better clarification on this, but given that the claimant was involved in the creation of OLAF and also helped OLAF develop its processes of machine learning and take in information, then it cannot be said that the claimant now says that there are biases in OLAF, despite the fact that they themselves helped OLAF be cured of such bias. Now turning to the specific information or other opinions that OLAF has proffered, claimant pointed to paragraph 21, page 9,
Which line?
at the third line, and it reads, Olaf also commented that the incident being the Sapura Bay bombings, could have been easily avoided if the government of Koltana had invested properly in counterterrorism measures and devices. Now, the claimant says that this is Olaf's opinion on the appropriate policy. However, this is a gross mischaracterization of the facts. In fact, the claimant themselves had entered into the CCTA after the fact that they had been affected by such bombings and cyber-terrorist attacks. Especially, the legal standard that we must look to is the fair-minded observer, and whether a fair-minded observer would consider this opinion to be one that would show justifiable doubts and an apprehension of bias on the part of the arbitrator. This opinion is a fairly neutral one that an objective person would in no means consider radical. Additionally, at paragraph 29, and this is at 9, the middle of the paragraph, the line that begins with OBH, it reads, Olaf in an article published took the view that the result being of the claimant's elections, were due to the claimant's incumbent party's poor performance over the past couple of years. Again, this is at page 13, paragraph 29. So in this case, the claimants mentioned that the phrase poor performance can be likened to Paranco and Ecuador, where the phrase used was recalcitrant to refer to the state Ecuador, which resulted in the recusal of the arbitrator. However, what they have failed to mention is that the opinion recalcitrant was mentioned in an article specifically relating to the dispute itself. So it was an interview of the arbitrator in relation to the specific dispute. In that case, it was clear that the judicial opinion of the arbitrator could not be trusted after he had made such an opinion about one of the parties to the dispute. This is clearly not applicable in this case because Olaf has mentioned these opinions in its capacity as a legal publisher of insights. So it is not so clear, and this is prior to the dispute at hand as well, and it is not so clear that this case cited by the claimants is appropriate in any case. And as for the specific standard as well, just to clarify on the law, mere opinions do not suffice to remove an arbitrator from his position due to the lack of impartiality, and this is as held in Obesan in Argentina as decided by exit. So this is why we argue that Olaf is an impartial arbitrator and cannot be removed from the present dispute. At this point, may I clarify if members of the tribunal have any questions before I turn to the second issue?
Thank you. Go on.
Okay, thank you. Turning to the second issue on the stay of proceedings, just to clarify the law on stay of proceedings, the discretion of this tribunal to provide a stay of proceedings is as provided for in Rule 13.1 of the AIAC rules. Now, as mentioned by the claimant, this is in order to ensure the expeditious conclusion of a dispute. However, as also rightly pointed out by the claimant, this must be balanced against the respondent's reasonable opportunity to be heard. Now, the claimants mentioned that there is no need for Anuwat to be present to proffer evidence. And this was in response to Justice Gant's question on whether Anuwat's statement has any bearing on their case. Well, their response in the procedural issues clearly contradicts the substantive arguments because in the substantive portion of the arguments, counsel for the claimant had mentioned that there was a Bitcoin robbery, and this was another statement that Anuwat had made at paragraph 39. So while the claimants say they do not seek to rely on Anuwat's evidence, Anuwat himself had made a statement on Bitcoin robbery, and specifically, this is found in page 16, paragraph 39.
So Anwat is going to be a witness for you?
We are seeking to adduce Anwar as a witness.
And what exactly do you expect him to say?
So this statement at paragraph 39, the second line, Anwar had, this is page 16, paragraph 39. The second line.
So you expect him to give evidence that Onion Ring had detected that politicians running the Koltana had been using the Bitcoin for their own expenditure?
We are not sure the veracity of his statement, since this was
No, are you expecting him to give that evidence, though?
We expect him to be present at this tribunal, cross-examined.
No, are you expecting him to give that evidence?
We are expecting him to give
That actual evidence?
the actual evidence.
What do you think he's going to say when he's in the witness box?
Well, we cannot make any conclusive statement on what he will say, but what we think.
Well, we won't actually know till he gives evidence, but what are you expecting him to say when he gives evidence? Because that must be the foundation for your application to stay the proceedings until you can have him come to give evidence.
Yes.
So I think we have to start by understanding the evidence that you expect him to give.
Yeah. What's the plan? What's the idea? What is it that you want to hear from Anwar that will help your case?
So in this case, there are two reasons why we think Anwar is key to these proceedings. And what we hope to hear from Anwar is firstly, the technical abilities, the scope, nature, and amount of information that the data collects, because the claimant's arguments are premised on a single statement made by a former employee of Initech, the creator of the Onion Ring software, while Anwar is a key programmer of the Onion Ring software. Second, we need clarification on this piece of evidence as proffered by Anwar, and we need to know the veracity of this claim because the claimant in their substantive arguments had argued that the Onion Ring software was unfit for its purpose or strictly did not fulfill its purpose, and there's a fundamental breach because of the fact that it was unable to prevent a Bitcoin attack. If it is found that these were not Bitcoin attacks, but rather there were other purposes that resulted in such a loss, then this is something this tribunal should be made aware of, and this can only happen if Anwar is adduced to the present proceedings. Additionally, we note that the claimant had mentioned that there is no relation between the ICC proceedings and the present proceedings. While we do acknowledge that the legal issues discussed at the ICC are distinct from the legal issues discussed in this proceeding due to the fact that the ICC discusses legal issues relating to the commission of cyber war crimes, in the ICC case and the Ulavu files, it mentions that Anwar was arrested for being a key programmer of the Onion Ring software, which forms the subject of the entire substantive dispute. Additionally, while the claimants also argue that perhaps Anwar can be adduced through video conferencing, this is an alternative the respondents have consciously considered and realized that it would not suffice. And this is because, firstly, while the respondents point to Rule 134 of the ICC rules to say that video conferencing is possible and is
Counsel, from the facts, do we know what's the time frame that we are looking at? How long will this arbitration take? How many days will be required? When will Anwar be called as a witness, if at all? When will the ICC trial take, and what kind of delay we are looking at? Because any application for a stay, relevant facts must be made on the circumstances of the case. So do we know?
We acknowledge that we cannot make any assurances on how long this tribunal's proceedings would take, because this would depend on the type of evidence the claimant gives this tribunal, which currently is only a single-page statement. And we also acknowledge that in the ICC trials, it is unclear how long those trials would take to conclude. So we do acknowledge that perhaps it is unclear the specific scheduling and logistical practical requirements. However, what we do know is the fact that the ICC proceedings have passed the pretrial chambers. I know that my time has elapsed. Perhaps if I could wrap up my answer to your question.
Yes, another 3 minutes.
Thank you. I thank you for your indulgence. So as for the trial at the ICC, we know it has passed the pre-trial chambers into the trial chambers, and this means that it is at a fairly advanced stage of proceeding, though we do acknowledge that appeal processes are something that must be considered by this tribunal. However, taking reference to ICC cases that are at a similar state of proceeding with a fairly compliant witness in custody, being Anwar, these cases, specifically ICC case number 10, prosecutor and Kalex Mabarishima, and ICC case number 9, the prosecutor and bar address Abu Garda. In these cases, the proceedings concluded in 323 days, less than a year, and 340 days, less than a year again. So in this case, our suggestion to this tribunal is that perhaps this tribunal could stay the present proceedings for 1 year, and taking reference to these cases, and beyond this period of time, of course with taking instructions and seeking agreement from both the claimant, this tribunal, and our client, we propose a stay of 1 year, and after that, we will take responsibility for risks and costs.
Have you got his agreement that he will actually give evidence, or will he just turn up and say, I refuse to talk?
On the record, it is not clear exactly where we are with Anwar, but since we do seek to adduce him as a witness, and that is a whole issue, the second issue of the procedural issues, the respondents will be making reasonable efforts to procure Anwar as a witness.
Well, if you are calling him as a witness, it's very easy for you to subpoena him. If you come to that, you know where to find him.
That is true, but this must be taken in consideration with the ICC proceedings and the serious nature of the crimes there as well.
Are there any particulars you can give us of how giving evidence here might incriminate him in his criminal trial?
Well, we could argue, okay, it could be possible that Anwar's...
Well, I think it has to be more than it could be possible, doesn't it?
It is possible that Anwar's evidence, as proffered here, may incriminate him in the ICC, but we do acknowledge that the proceedings at this tribunal are kept confidential, and that perhaps this would not be such a big issue if all parties make an undertaking to ensure that the information given by Anwar are secluded to the purposes of this proceeding and do not prejudice him in any way other than that.
Thank you.
I thank you for your time, and if there are no other clarifications I may make.
No, thank you.
This concludes my submissions.
Yes, Ms. Lowe.
Can I check if I'm audible? Good morning. Okay, thank you. Good morning, members of the tribunal. My name is Alyssa Lowe, and I appear on behalf of the respondents, the Majestic Kingdom of Rajasthan. I'll be speaking for a total of 20 minutes in addressing my learned friend's arguments on the third and fourth issues of whether the CCTA is void or, in the alternative, validly terminated. Members of the tribunal, since World War II had ended, the respondents and claimant states have been collaborating with each other on many mutually beneficial projects, the latest one being the formation of the CCTA. Although Onion Ring had benefited Cortana significantly by improving its national security, Cortana had not only terminated the contract without any valid reason, but also refused to fulfill its payment obligations. And this appears like an attempt by the claimants to shirk its contractual responsibilities after it had reaped the benefits of the CCTA. In light of this, we make two main submissions. First, the CCTA is not void for illegality because it is not opposed to the public policy of the right to privacy. Second, the CCTA is also not validly terminated because no fundamental breach had been committed by our clients. And in fact, at every step of the way, our clients have readily assisted Cortana in combating terrorism and other transnational threats. Turning to the claimant's first argument as to the fact that the CCTA is void for illegality, the claimants say that the purpose of the CCTA is to combat cyber terrorism and other transnational threats. However, they contend that this infringes on the privacy of Koltana citizens because it necessitates an illegal action of bulk interception. And to support their contention, they cite the 2017 Indian Supreme Court case of Justice K.S. Puttaswamy and the Union of India, stating that the right to privacy is a fundamental right enshrined in Article 21 of the Indian Constitution. We do not dispute that the right to privacy is fundamental. However, the claimants have conveniently left out the fact that the court emphasized that the right to privacy is not an absolute right. And therefore, for there to be a lawful derogation from the right to privacy, it must fulfill the tripartite test of legality, legitimate state aim, and proportionality. And here we say that the most contentious point would probably be the element of proportionality, which is fulfilled in this case. And in order to support this contention, we would like to refer to the facts of Justice K.S. Puttaswamy. So in that case, the constitutionality of the art project, which gave access to poor Indian citizens, access to welfare benefits, required the collection of very sensitive information such as biometric data, personal home addresses, email addresses, and names. And we must emphasize that these biometric data consisted of fingerprint scans as well as iris scans. And despite this, the court held that this was considered a minimal intrusion into the privacy of Indian citizens, because the most important thing here is not that the right to privacy must be safeguarded at all costs. Rather, it must be balanced against other fundamental rights. And in that case, the court held that the right to food and shelter, which the Aadhaar project would grant to Indian citizens, would outweigh the right to privacy in that case. And further, there were also safeguards as to the data collected under the project itself, which is another reason why the court held that there was no derogation, unlawful derogation from the right to privacy. And we submit that it is proportional in our case as well, because the onion ring software had only collected minimal data such as the names, email addresses, personal addresses, as well as phone numbers of Koltana citizens. And this cannot be said to be more intrusive than biometric data like fingerprint scans as well as iris scans that could identify a person immediately. And further, it must be balanced against the right to national security.
Sorry, fingerprints and iris scanning, they don't track a person's behaviour. They can be used to identify the person. But onion ring, as I understand it, tracked everybody's behaviour.
Mr. President, we acknowledge that onion ring could be used to track everyone's behavior, but we must point out to this tribunal that what the claimants had left out is that the claimants had unilaterally taken the decision to put the onion ring software into CCTVs of their state without our consent or our input. And this had given rise to a heated debate among Koltana citizens as to concerns that the Koltana government themselves are spying on the citizens unlawfully. And while we do not purport to say that...
Sorry, so you say that they've misused the software, and to the extent they've misused it, it's a breach.
No, Mr. President, we are not saying that the software was misused. In fact, this is exactly what the software was intended to do, which is to predict terrorist plots and to prevent them. However, the claimant cannot have its cake and eat it. In other words, it cannot enter into the CCTA with the goal of using the onion ring software to surveil its citizens, and after it had reaped the benefits of the CCTA, turn their backs on the respondents and say that we have infringed on the privacy of their citizens, because this is exactly what the claimants had bargained for.
But they say that we're bound by the Indian law with respect to privacy, and that this software installation would be a breach of people's privacy. And as a result, it's contrary to public policy under Indian law.
Mr. President, we know that is the claimant's submission, and we will be addressing it now. So,
does it go to the root of the contract?
Dato Ma, may I clarify if you mean that The
alleged
breach.
breach.
The
Does
breach
it go
being
to
the
the root of
infringement.
contract?
No, Dato' Ma, it does not go to the root of the contract, because to determine whether a breach is fundamental, which goes towards issue 4, termination, we must look at whether the breach had substantially deprived the innocent party of the entire benefit of the contract it was supposed to obtain. And to look at what the intended benefit was, we have to look at what parties had intended, and in this case, it was to assist Cortana in combating cyber terrorism and other transnational threats. And if we could direct this tribunal's attention to page 12, paragraph 27 of the record. Can I clarify if this tribunal is with me?
Page 12, paragraph.
27.
What relief do you expect from tribunal?
Apologies, Mr. Justice Babu. Could I clarify your question?
What relief do you seek?
I see. The relief that we are...
I want to ask you also, what relief do they expect? What relief do you expect from us? From this tribunal?
Yes, Ms. Antong.
Mr. Arbitrator, we are expecting for this tribunal to cause CCTA to be void because it is operated in bulk interception, but not targeted interception. Thank you.
Yes, please. Continue.
I will address Justice Babu's question first before I turn to yours. Justice Babu, the relief that we are seeking is that, of course, we would like to continue the contract with the claimants, given the long-standing relationship that we have had with them. However, given that the claimants have completely turned their backs on us, then we would like to claim damages for the remaining period of the contract. And every year, the subscription to the Onion Ring software costs roughly 100 million USD worth of Bitcoin. And if the subscription service is 4 years long, then we would like 400 million USD worth of Bitcoin, because that is what we were owed and what we would have received if it weren't for the claimant's willful termination.
You'd get less than that, wouldn't you, if it's to be paid up front as opposed to being paid over a long period?
Well, Mr. President, if we look at the contractual requirements, which can be found under... Apologies.
But what I mean is the value of $100 million today is more than the value of $25 million a year for 4 years.
Mr. President, are you referring to the time value of money that could easily be adjusted by certain calculations? And we would certainly take that into account because we would not want to shortchange the claimants. Turning back to Dato' Ma's question on whether there was a fundamental breach, a fundamental breach is one that substantially deprives the innocent party of the entire benefit of the contract it was supposed to obtain. And I earlier referred members of the tribunal to page 12, paragraph 27 of the record. At the last few lines, you can see that, and I read, that reports from the government's Security and Intelligence Department indicated that the Onion Ring was able to identify and prevent several cyber attacks and terrorist plots, contributing significantly to the overall national security of Cortana. And given that the benefit of the contract was for Cortana to combat terrorism, it does not lie in the mouth of the claimant to argue that they had been substantially deprived of such a benefit.
Well, basically, it's because the agreement, the consideration is of such high value, they wanted a
Foolproof system, a foolproof software, and they didn't get it. So isn't that fundamental enough?
Well, Dato' Ma, we would all like a foolproof software so that we can prevent terrorism everywhere in the world. Unfortunately, that is not possible because softwares cannot be 100% foolproof.
Well, you want a foolproof arbitrator? Anyhow, please.
Well, perhaps I can ask, where is it set out that there were any restrictions on the reliance upon this software, where it said that it may not be foolproof or it may not stop theft of Bitcoin? It's not like a $50 piece of software where people would ordinarily expect it to be imperfect. It's very expensive software.
Mr. President, unfortunately, nowhere in the record provides the amount of success that the respondents have promised the claimants through the onion ring software. However, if we take a look at real-life examples, for instance, even Palantir software that is used by the USA in the FBI and CIA agencies are not foolproof as well, because we can see that the USA still faces terrorist attacks, be it internal or external. And so we submit that no software can be foolproof, and it is unlikely that the respondents will undertake that the onion ring software will be 100% foolproof. And we would also like to point out to this tribunal that the claimants say that we are responsible for the loss of their Bitcoin. But if we could refer this tribunal to page 16, paragraph 39 of the record, at the first few lines, the line beginning with informed, second line, states that Anuwat informed members of the media that Onion Ring had detected significant amount of Bitcoin expenditure, transaction, and or movement within Cortana involving the bank accounts of senior DPP politicians. And may I remind this tribunal that these are the politicians of the incumbent party of the Cortana government. And so there is some suspicion that the Bitcoin was lost owing to the corruption and incompetence of the Cortana government. And while we do not purport to undertake that Anuwat's statement is 100% true, it is our position that it raises some suspicion as to whether the Bitcoin was truly the fault or the lapse of the Onion Ring or due to the corruption of the Cortana government. And this is why we need Anuwat to be present before this tribunal to testify as to whether this statement is true, and to allow Anuwat to be cross-examined by both parties in order to test the veracity of his statement.
Why would we let you cross-examine him if he's your witness?
Apologies, may I clarify your question?
Why would we permit you to cross-examine your own witness?
To examine him, you mean? Yeah?
I apologize, members of the tribunal, perhaps I misspoke. We would like to examine him and give the claimants the opportunity to cross-examine him, because we believe in the reasonable opportunity to be heard before this tribunal today. Turning back to my earlier submission that the CCTA had not breached the public policy of the right to privacy, we say that the proportionality element is fulfilled because the right to privacy of Cortana citizens must still be balanced against the state's prerogative to protect its national security. And on the record, it states that perhaps only names, personal addresses, email addresses, and phone numbers were collected. And this cannot be said to be a deep intrusion into the privacy and private lives of citizens. And the CCTV surveillance footages are not the doing of the respondents and are entirely the doing of the claimants. And so those actions cannot be imputed on the respondents and on the CCTA. And therefore, given the minimal intrusion into privacy balanced against the fundamental prerogative of a state to protect its own national security, we submit that the measures taken by the Onion Ring software are wholly proportionate, and there is a lawful derogation from the right to privacy. We would also like to address the claimant's mischaracterizations of the authorities that he had advanced to this tribunal. Earlier, the claimants argued that the PUCLK stands for the prohibition against bulk interception, but we would like to clarify that this was not the holding in the case. In the case, the action of telephone tapping instead was challenged as a serious invasion of individuals' privacy, yet the court held that because Section 5, subsection 2 of the Telegraph Act permits the interception of messages in circumstances warranting a public emergency or an interest in public safety, the court held that telephone tapping was not an infringement in the right to privacy. And in light of this, it affirmed that collecting such information is in the interest of national security and cannot be faulted. Apologies, if I may have a moment. Further, the claimants also argue that the right to privacy can only be infringed where a person has past criminal record or poses a criminal threat to society, and they then again cite the PUCL case as authority for that. But as I've already mentioned, the PUCL case refers to telephone tapping, and instead, we believe that the claimants are referring to the High Court cases of MP Sharma and Karak Singh. And we would like to point out to this tribunal that in those cases, the court held that the right to privacy is not fundamental, and therefore it has been overruled by the Supreme Court in Justice K.S. Puttaswamy and the Union of India. And therefore, those cases are not good law, and we submit that the right to privacy must go through the tripartite test that I have brought this tribunal through earlier. And it is our conclusion that the right to privacy has not been infringed on.
If the right to privacy has been infringed, is that the end of the matter, or is there a question about whether the public policy that's referred to in the Indian statute wouldn't apply because the conduct was legal in Koltana?
Mr. President, I noted that you had earlier posed this question to the claimants as well, and to that they said that because Indian law governs the matter, then we would have to reference to Indian law. And we do agree, and we add that because this is an international contract between two sovereign states, it is irrelevant that one or the other state's laws permit this, because we must find a neutral and common ground to adjudicate matters on. And therefore, we have chosen Indian law to adjudicate any dispute arising from this agreement. And earlier, I noted that members of the tribunal had asked why the claimants had retained the onion ring software, even though they had complained that the onion ring software infringes on the right to privacy of its citizens. And to that, we have 2 points in response. First, it is an undisputed fact that the onion ring software is integrated into Koltana's vital government systems, data and internet systems, and this can be found at page 12, paragraph 26 of the record. And if Koltana is right that the onion ring software is really so invasive into the citizens' privacy and is really misusing their data perhaps, then one would expect them to want to remove the software as quickly as possible.
But what I understand is that from the claimant is that it's not that they want to use it, but they want to retain it for purposes of investigation. Are they not entitled to investigate what has gone wrong?
Dato' Ma, of course they are entitled to investigate what has gone wrong. However, we would like to point out to this tribunal that they have been investigating since March 2022, and it has been 1.5 years since the investigations had started. Yet they have not shown any conclusive or direct proof and rely only on... Members of the tribunal, I note that my time is up. If I may have 30 seconds to wrap up.
Yes, we'll give you another 3 minutes.
Yet they have not shown any conclusive evidence or direct proof, and this can be found at page 16, paragraph 40 of the record. At the middle of the paragraph, where President Lalan cited that the onion ring software is to be retained for investigation purposes.
But even if they gave it back to you, wouldn't you have to give them a copy again as part of the discovery process for this hearing?
Well, Mr. President, we would have to take instructions on our clients for this, but this would probably be subject to a compromise struck between the two parties, and we would be willing to assist the claimants in investigating this matter. However, we stand by the fact that the onion ring software is not as intrusive as the claimants contend. And further, we urge this tribunal to direct the claimants to adduce findings of the investigations that they have conducted into the onion ring software to determine whether the intrusion into the right to privacy was so fundamental as to entitle the claimants to terminate the contract. And it will be in the interest of the tribunal to adduce that, since that is the only piece of evidence that they can show to allow this tribunal to make an informed decision on whether the right to privacy has been infringed on. Members of the tribunal, I've come to the end of my submissions. If I could clarify if this tribunal has any more concerns.
No, thank you.
Thank you so much for your time.
Now, Ms. Devon, just a moment.
One moment.
Switch off your mic.
Ms. Devon, did you want to make a reply?
You want to say anything, madam? No, we have finished our duties.
Did you want to make a reply, Ms. Devon?
Your rebuttal.
Yes,
Your
yes,
rebuttal?
members of the tribunal.
Yes, well, you can start now, sorry.
Members of the tribunal, we have 3 points of rebuttals. On to the first point in relation to the virtual hearings. Now again, we are not denying Anuwat's right to a fair hearing. Instead, we are proposing for a virtual hearing, which is the most fair and viable solution, which would ensure a win-win situation. Now, the AIAC themselves have released a protocol on virtual arbitration proceedings, which would ensure the most fair trial to both parties. Further, members of the tribunal, we are in the year 2023. Technology has advanced to the point that the respondents themselves has appointed an AI arbitrator. Now, how is it that an AI arbitrator may be appointed by the respondents, but the respondents may not resort to a virtual hearing, which has been adopted by multiple international arbitration centers, such as the AIAC itself, as well as the ICC, as well as Indian courts. Now, further on to my second ground of rebuttals. In relation to Anuwat's testimony, as referred to by the panel of arbitrators earlier, we question the respondents' response to Anuwat's testimony. Here they refer to paragraph 39, my apologies, in which Anuwat would testify that the Bitcoin robbery was in which Anuwat would testify regarding the Bitcoin robbery. Now, this would mean that Anuwat has access to Onion Ring, which would directly incriminate himself, as this would contravene the CCTA as agreed upon by both parties that information from Onion Ring is only accessible to the claimants. Therefore, we question whether Anuwat is even necessary at our current proceedings. And on to our third ground of rebuttals. The respondents claim that we turned our backs on the respondents after we had enjoyed the benefits or the success of Onion Ring. And to this, we appreciate the success of Onion Ring and we acknowledge it. However, the fact that it has been successful does not negate the fact that the very object and nature of the CCTA of bulk interception is illegal. And further, even if there has been oversight from both parties that bulk interception is illegal upon entering the contract, we submit that this would only be relevant when assessing the damages. Further, putting the respondent's submission at its highest, that Onion Ring is proportionate as one of the limbs under the three-part test, this still does not fulfill the other two tests of legality and necessity. Therefore, as this test is conjunctive, it is on the respondents to fulfill that all three tests, to ensure that all three tests have been fulfilled, or the breach of the right to privacy is illegal. Therefore, members of the tribunal, it is the claimant's submission that we are not here before this tribunal to seek any enrichment of any form. We are merely seeking for the right to a fair trial and hearing and to seek justice. Thank you.
Yes, Ms. Jana.
Members of the tribunal, 3 points in rebuttal. First, on the point of virtual hearings. Again, we have not denied that virtual hearings would be useful by virtue of the very fact that virtual hearings, the fact that it's online, is insufficient. Rather, we are arguing that the nature of the hearing and the type of evidence we want to adduce is something we cannot get virtually. For example, if we want to run a trial run of software and have Anuwat perhaps with another expert witness in a process of hot tubbing where we can ensure that perhaps we get the most credible testimony and also verify the veracity of his evidence, then this cannot be done virtually, and this is why we argue that a stay is
Just 1 minute.
required.
Pause. Are you calling Anuwat as a witness of fact or as an expert? You mentioned hot tubbing, so you want him to be in hot tubbing with your experts or what?
Well, in this case, since arbitral proceedings do not preclude both from happening, and since we can adduce him as both a factual and an expert witness, this would only enhance the benefits that this tribunal can gain from adducing Anuwat as a physical witness.
Sorry, do you think that we'll allow you to hot tub a witness who's being called to give evidence of fraud on the other party? Because his evidence is that the other party's officials fraudulently took the Bitcoin. It seems like a very serious issue to have somebody in a hot tub like a couple of valuers on expert evidence.
As for his statement at paragraph 39, we are not using it to say that the claimant has fraudulently has committed fraud and therefore is unable to be able to fulfill its obligations. We will use it or use him as a factual evidence to ensure that this statement, what was his state of mind when he was making the statement, why he made the statement, and how we can assist this tribunal's finding on whether the CCTA, the contract, is void, or in the alternative, validly terminated for fundamental breach, since the claimants had mentioned that there was a Bitcoin attack, while here it seems that there may be something else going on. So we do need him here. And just to add on, justice hurried is justice buried, and even if the contract between the CCTA itself does not concern issues at the ICC, and the ICC proceedings may take long, which is the reason why the claimants suggest that we have virtual hearings. Anuwat is necessary in order to unveil the justice of this case. This, turning to the third submission of the claimant, they argue that in this case, the benefits of the contract were reaped by them, but the problem is the fact that the software had access to information in breach of privacy. However, they also said that they appreciate and acknowledge the amount of information that the software has collected, and the help that it has provided to the claimant. They had also mentioned that there was oversight on both parties in entering the contract, but we hope to point out to this tribunal that the claimant had entered into this contract with their eyes open and consented to such collection of data. Additionally, when they bring up the test on legality and say that legality is something that this tribunal must ensure, then we argue that it is disingenuous of the claimant's government themselves, who had consented to entrance into the contract, to later say that there are no laws providing for this and proffer no evidence to this end. This concludes my rebuttals.
Thank you.
I thank this tribunal for your time.
No further comments from...
This arbitration is now adjourned. Counsel and observers, please exit the room to allow the arbitrators to deliberate. You may enter when the arbitrators have finished deliberation, which will usually last about 15 minutes.
The audience is required to leave the hall. The first 4 rows. To my right, everyone will exit using the left door. The first 4 rows, please, starting from the bottom. All right, we'll start from the end. The first 4 rows. To my right, everyone will exit using the left door. The first 4 rows, please, starting from the bottom. All right, we'll start from the end. The first 4 rows. To my right, everyone will exit using the left door. The first 4 rows, please, starting from the bottom. To my right, everyone will exit using It would be preferable if you take the same seats without causing any confusion. Anything else after this?
So photo session is going to happen, ma'am. Right after the feedback. I'm going to welcome them all.
It would be preferable if you take the same seats without causing any confusion.
Photo session is going to happen, ma'am. Right after the feedback. I'm going to welcome them all. I request the audience to kindly settle down as soon as you can. Another quick reminder to kindly keep your cell phones on silent mode, please. And please do maintain the decorum of the event.
Thank you.
Ladies and gentlemen, welcome back. We would now like to invite the panel of arbitrators to give their comments on the session.
Thank you. Can I start by saying how incredibly impressed I was by the quality of the mooters, their preparation and their arguments. It was marvellous and, frankly, better than a lot of lawyers I see in court day to day. I was very impressed with the way that you sifted through the facts. It took me a long time to read the 18 pages, half of which was irrelevant. And I noticed that you all managed to get rid of the irrelevant parts and focus in on the relevant bits for the dispute. That's a very important skill, and it sounds easy to say it, but it's very hard to do, as you've probably experienced, going through over and over, working out which facts are actually relevant. I was a little perplexed that one team abandoned the arguments about AI not being able to be an arbitrator, when clearly you had two arbitrators on your side for that argument, and yet you jettisoned it. And similarly, the other team clearly had at least one arbitrator on side about the public policy argument, and yet you jettisoned that as well. I'm not quite sure why you wouldn't grab the lifelines if the court is going in a particular direction that suits you in order to hang on. But that comes with time and experience. Sometimes you don't want to do it because you're convinced that the next court up on the appeal would overturn it anyway, so you don't want the court to go into error. I thought that you all engaged very well with questions. I know that I asked quite a lot of questions, and I'm sure that they were quite difficult to answer on the fly, and that, of course, is the point of them. And perhaps it's an example about where AI would have trouble, because some of the questions were drawing analogies to things quite different to what we were talking about in order to make a point. And I thought you did very well in engaging with that and being able to talk about the issues that arose from that. I was impressed that you knew the facts so well that you could easily go to a particular paragraph or line in the material in order to be able to identify the factual basis for what you were saying. So I just conclude by saying I thought you did very, very well. I did wonder whether or not we could make it a tie, but we can't. So at worst, it's certainly very, very close. Yes, thank you.
Thank you. Thank you, Mr. Chairman of the Tribunal. A very, very good morning still, ladies and gentlemen, and in particular to our voters. I really say you did a marvelous job. Both teams, you have done a wonderful job. And to know that you are students will be something that if any person that's listening will think they are all senior practitioners already. But really good to know that you have made a good job of it. I got to know the MOOT problem only yesterday afternoon, thanks to Mr. Raphael, and spent some time looking at it. And I must say that both teams, you have managed to sift the relevant and the irrelevant points. As pointed out, it's a very long MOOT problem, 18 pages. A lot of the historical parts were not quite necessary, quite irrelevant, but you have done well and zoomed into the main points. We must not forget what the purpose of mooting is all about, and that is to prepare students for the real world. I'm having a cup of tea here while I'm sitting and talking to you because it's a moot court, but in the real life, we can't be having drinks and tea while hearing a case. But to be able to take part in a moot competition is to prepare yourselves for the future. And what is really important in a moot competition is not so much, and we don't make a decision on the merits of the case. Yeah, we don't make a decision on that, but we mostly make decisions and give points on your knowledge of the facts, knowledge of the law, how do you sift and disregard irrelevant facts, and importantly, advocacy. Because advocacy is how you persuade people or judges to come along and agree with you. You may have the best game plan, but if you cannot deliver that, it will be lost. Yeah? So being able to advocate and articulate yourself is very important. And importantly, really, to me, is the ability to answer questions. Moot judges are terrible people, and that's why they're selected to come and sit here to ask difficult questions. Yeah? And I think all of you done very well in answering questions. Pressure is there. Everybody is listening and looking at you. The timekeeper keeps on telling you 1 minute, 2 minutes, you know. So there's a lot of stress and a lot of pressure. But I think it all holds well, and I'm sure your future will be very bright and go on from layer to layer. And I think the fact that we have an onion ring as the name of the company or name of the software is very appropriate. Different levels of success, different levels of expectation. So maybe you are right at the top of the layer onion ring now, or somewhere reaching to the top. So I wish you well, and as they say, see you in court one day. I do not know even whether you are a second-year student or a final-year student. That didn't matter at all, because what really matters is how you delivered your arguments. Thank you. Congratulations.
I chose to say a few words last, because I have the largest experience, much more than my other colleagues here. For over 6 decades I have been in this profession. Now I can tell you one thing, that each one of you have done so well that I wish the lawyers, the stalwarts who appear before me, were as well prepared as you are. And the facts that have been put forth are not very clear. There are many red herrings in it. You discarded those red herrings, sifted the facts, analyzed it, and presented beautifully. But it is difficult for us to make a choice as to who is better than who. But forget about it. Don't say how we can choose who is better than who. We won't do it. That is just by some quirk of each one's mind. We pick one or the other. But that doesn't mean any one is inferior to the other. All of you are equally good, or each one is better than the other. One motto is there in Olympic Games: play the game, not to win, but to participate. That's what you have done. I congratulate all of you. Thank you very much for giving me this opportunity.
We would now like to invite the council and the panel of arbitrators for a group photo on the stage.
Oh, that's it. We sit here. Okay.
They will stand. They have a standing, they have a sitting.
The winner will be announced during the closing and award ceremony later this afternoon. Thank you.
Behind us? Yeah. Oh, maybe you can move our table a bit forward? Oh. Oh, this is going to fall apart. Small and thin. Very small table. Thank you. That's it? Yep. Yeah, okay. Sorry. Thank you.
Good morning to one and all present here.
All in 30. All in 30. Yes.
I was in Indonesia. When the chairman of the Human Rights Commission, in that capacity, I came there. I was in Indonesia speaking
As we conclude the final rounds of the 18th LAWASIA International MOOT competition, I now request Shri Srinivas Murthy, CE of GEF Medical, and Shri B.S. Ramprasad, CE of GEF Engineering and General Sciences, to felicitate our honorable judges of the finals of the 18th LAWASIA International MOOT competition by handing over a bouquet of flowers and a memento. Ladies and gentlemen, kindly put your hands together for our Honorable Chief Justice of India, Honorable Chief Justice S. Rajendra Babu, former Chief Justice of India.
Wow. This is a customary way of honoring people.
This Honorable
Yeah, you can keep that there.
That was Honorable Justice Grant Ruth Miller, Judge of Federal Circuit and Family Court of Australia. Next we have
to me, is it?
Honorable Justice S. Rajendra.
Thank you very much. Thank you.
Next we have Dato' Now Weng Kwai, retired Court of Appeal Judge of Malaysia.
Thank you. Hope to see you again and again. Please. What a big bouquet of flowers. Yeah. Not used to receiving flowers.
And lastly, Honorable Justice S. Rajendra Babu, former Chief Justice of India.
So great. Just a minute.
Different book, same book. Yes.
Ramaiah College of Law.
The child, what different games?
This is from
Like child chases.
is it from the Ramayana, is it? Oh, just some- Krishna, yeah? Krishna is a child.
Thank you, sir. Thank you, sir. I would request the audience to kindly remain in the hall as our dignitaries take leave. Request you to kindly rise as our dignitaries leave.
Okay, I think we are to leave. What am I going to do with this flower? Oh, thank you. Yeah, okay, please. Yeah, thank you.
I request all faculty members to kindly come up on the dais for a group picture with the honorable dignitaries, including the international delegates who are here with us. Oh. They're leaving. Where?
They're going to sit there for some time.
Faculty members and international delegates are requested to join us in the briefing room, which is adjacent to the hall, for a group picture.
I'll be in chaos.
So we're doing this picture outside.
Yeah, we're doing it in the room at
Hi. How are you? See you again. Keeping well? The very first meeting was with you. You were the lead judge. Gosh, that was in 2008. It was ages ago. Yeah. That long, huh? It's a long time. My goodness, yeah. The MOOT has come a long way. And thanks to Raphael, he's a guy that's been pushing it and organizing it every year. This guy's a hero. Yeah, it's so long. Next year, we'll be in Kuala Lumpur again. Yes, at the conference, and the MOOT will be there as well. October. So exactly a year. I'm looking forward to seeing you there again. Yep. Well, and you attend without fail, right? Every year, I think. I do, pretty much. Fantastic. Are you attending the conference?
Actually, I haven't been attending the conference. I've just been judging.
You came especially for the MOOT competition?
I did actually.
Only?
Yes, I did.
My goodness, talk about commitment.
Well, I believe in this MOOT. So,
yeah. I think the students deserve a lot of advice and cooperation from senior members.
Well, they're fantastic. They deserve everything they get.
How many teams actually took part this time?
This time was only 7 teams. At this round.
Okay.
So it's smaller than usual, but I suspect in KL it will be bigger.
I would think so, yes. Good. More competition. Thank you. Thank you.
All right. I'll guide them. The briefing room, please. Briefing room. All the faculty members are required to go to the briefing room where the judges would be for a group photograph. And international delegates, volunteers kindly escort them to the briefing room. Small announcement, someone seems to have misplaced their keys. I'm not going to say which keys. If you misplaced a set of keys, kindly come onto the dais, meet Aniket, a round of interrogation on what keys, and if you seem to be the truthful owner, then we'll give it to you.
Students have to remain seated for the attendance.
Kindly be seated for your attendance. Most important. Thank you. Yeah, I need to go for photograph.